Well, thank you. I will be talking on the legal implications of the Water Framework Directive, if everything goes well. That is a very broad topic, so to give it some direction, I have narrowed it down to the recent rulings from the European Court of Justice on the Framework Directive. So before I enter into that, maybe I should tell you why I'm doing the presentation on this. So back in January, I get an email that a Danish participant is needed for the planning committee. Anders from Norway had told Marianne that I was working with the Water Framework Directive in the strategic coordination group, so she could contact me. So I entered into the planning committee, and as I'm a legal advisor, I was tasked with finding somebody to present on this topic. I thought, I can do that. I'll ask around. And in case everything falls through, I can do it myself. So as you can tell, everything fell through, so here I am. What we have been doing is that I have a colleague who is in Denmark, so if all the technical stuff works, he will be joining us at the Q&A, and he can help me answer some of your questions if you have any at that time. So why did I think that I could do this presentation? I'm a legal advisor on the Water Framework Directive in the Ministry of Environment. But before that, I worked in the legal division in the ministry, and prior to that, in the EU and international division, and all the time on the infringement cases and the cases at the European Court of Justice. So I've been representing the ministry at the court a couple of times, so I thought I can do this. So here it goes. So I have 20 minutes, and how do you tackle this topic? And what I decided to do was to present an overview of the cases that is handed down by the court since the last conference. That'll be the primary part of this talk. Then I'll briefly touch on the trends in the ECJ rulings, as meaning what kind of school the interpretations are following. And then I'll point you to a link at the Water Framework Directive page where you can keep track of all the rulings. It's something others also pointed me to. So that is a good place to get to know more about the cases. So I will run through the cases that has been handed down since the last conference in 2019. It's not a fully complete overview. There's actually one more case. It's a Spanish case where the Commission took action against Spain for not having made public the revised water river basin management plans. At a certain point, I decided to leave it out. So just so you know, this is not a fully complete list. But what I'll do is briefly introduce the cases. The slides will be a little bit loaded, but then you can use it to go back and look into it in more detail should you need to do that at a certain stage. So here's a loaded slide. It is, with respect to Article 9, water services, a very relevant article, but this time this case is a bit different. It had to do with Spain having introduced a tax on the use of inland waters for electricity production. So the producers did not appreciate that tax. So they brought action to the Supreme Court in Spain, seeking annulment of the decree. The question before the ECJ was then if a tax that was made solely for income-generating purposes and not environmental protection, would that be in line with Article 9, the water service provision? And the court ruled that, yes, actually that was acceptable within the scope of Article 9. This is one of the really important cases that has been handed down, the C535/18, what we in Denmark refer to as Detmold. And the original case is a German case. There was a decision by local government to approve a plan for the construction of a section of a motorway by Bielefeld. But this would entail runoff of rainwater to the surrounding surface and groundwater. So we know from the Weser case, which is before last conference, so I'm not dealing with that one, but we know from the Weser case what would constitute deterioration of surface water. But as there was uncertainty about the deterioration of groundwater, preliminary questions were put to the ECJ. And here they asked if what would then constitute deterioration. Would it be deterioration of the status of a groundwater body if at least one EQS or threshold value for one parameter is exceeded, and if the relevant threshold has already been exceeded, will any additional increase constitute the deterioration? And here you can see the court's ruling. It is actually yes on both counts, which align this ruling with the Weser. But the court added that the values measured at each monitoring point must be taken into account individually. So I just have to say, with respect to the illustrations, the top one, some of you may recognize it as part of a presentation the Commission did on the Weser ruling. We tried to make some sort of illustration that could picture the same as for groundwater, but it hasn't been vetted by the Commission or anything. It's just what we use in the ministry. Here we have the definition of deterioration when it comes to groundwater. Then the question, of course, will be what then for the status of the whole groundwater body. That is a different aspect. You will have to look into the Groundwater Directive and make the assessment, which is stipulated in Annex 3, to see if it's such a such a big impact that it influences the classification of the groundwater body. But that's a different aspect. Here, this is just a deterioration, the question of deterioration, based on the EQS. The next ruling also has to do with deterioration of a groundwater body. That's a Spanish case, the Doñana National Park. Here it is surrounded by intensive agriculture, and since before the Water Framework Directive, more groundwater has been abstracted than is recharged. So does that constitute deterioration in the sense of Article 4 of the VFD? And actually, it does not. As long as the excess abstraction remains at the same level, it is not deterioration. The case went against Spain anyways, because the river basin management plan they had produced did not take sufficient heed of the illegal groundwater abstraction, so they lost the case anyway. Here, as a recent ruling, also on deterioration, now we are looking into if temporary deterioration also constitutes deterioration in the Article 4 sense, or could there actually be some room for deterioration as long as it's not a lasting deterioration? And here the court was asked if that was in line with Article 4, and they say that you need to interpret the directive so that when you assess a project, you have to take into account temporary deterioration. This was actually already in the Detmold case. In para 101, it says that even a transitory deterioration of water is authorized only subject to strict conditions, which means you need to apply Article 4.7 if your project is entailing temporary deterioration. So I have underlined a section of the ruling. This is just because it was discussed in the strategic coordination group, and the Commission was sort of okay with the ruling. They thought it fell in line with the other rulings, and the court had added this underlined sentence that was not in the General Advocate's opinion, so they thought that was important. So this constitutes deterioration. What the Commission didn't like so much was that they had argued, or it was argued, that the monitoring program could be used to establish if there was a temporary deterioration, and that the court didn't accept. There are too long spans for some of the measurements. Here, the last case that I will mention is really an outlier. It's a direct case, which means that the Czech Republic took out action against Poland due to Poland approving the Turo mine to continue till, I think it was 2044, and that affects the groundwater in the Czech Republic, and they did not appreciate that. So the case is more on impact assessment, but a certain point, a part of it deals with what if they were arguing that the impact assessment decision didn't provide for a procedure for the case that exemptions in Article 4 are withdrawn. It's really an outlier. The general advocate didn't agree with the Czech Republic, and once he had given his opinion, the case was settled between the Czech Republic and Poland, struck from the books, but there have been different proceedings in the case. So in the meantime, Poland had incurred a penalty of 68 million euros for not adhering to, not stopping the mining process. So these were the cases, and I'll just briefly touch on how the court is interpreting the directive when they have the cases, and what they're saying, that their case law is based on interpretation of the wording, the objective, and the context, and especially the objective. So we know with the Water Framework Directive that the objective is to ultimately reach the objective of good status. So when the court is considering a case before it, they will think, so what should the ruling be in order to reach that objective, reaching good status? So there's really no way around it. There isn't any room, and from what you can tell from the ruling on deterioration, basically you cannot deteriorate anymore. That does not compute with reaching the objective of the directive. And finally, I'll just show you this. You of course know the curia. The interesting part is the link here. It'll lead you to the Water Framework Directive, but at a section where it lists all the court cases. So you can actually check if I've forgotten some, and you can also check the documents that were submitted to the procedures before the court. So all the arguments that have been put forward to the court, and sometimes if you need a good argument, good reasoning, maybe there's something there that you could use. So that was what how I would go about talking about the legal implications of the Water Framework Directive for now. Thank you.